Hey everyone. So we're beginning part 3 of the rules of the Supreme Court of the United States, which is the jurisdiction on writ of certiorari. And there are 1, 2, 3, 4, 5, 6, 7, it looks like, rules just about the jurisdiction on writ of certiorari. So I'm probably going to read, let me see, maybe 1 through 12, because those are fairly short and they start getting pretty long after that. I might even read to 13, we'll see. Okay, so Rule 10, considerations governing review on certiorari. Review on a writ of certiorari is not a matter of right, but jurisdictional discretion. A petition for a writ of certiorari will be granted only for compelling reasons. The following, although neither controlling nor fully measuring the court's discretion, indicate the character of the reasons the court considers. A United States Court of Appeals has entered a decision in conflict with the decision of another United States Court of Appeals on the same important matter. Has decided an important federal question in a way that conflicts with a decision by a state court of last resort, or has so far departed from the accepted and usual course of judicial proceedings, or sanctioned such a departure by a lower court as to call for an exercise of this court's supervisory power. B. A state court of last resort has decided an important federal question in a way that conflicts with the decision of another state court of last resort or of a United States Court of Appeals. C. The state court or United States Court of Appeals has decided an important question of federal law that has not been but should be settled by this court, or has decided an important federal question in a way that conflicts with relevant decisions of this court. A petition for a writ of certiorari is rarely granted when the asserted error consists of erroneous factual findings or the misapplication of a properly stated rule of law. Okay. So, that doesn't sound good. But I have to do research too on similar cases to mine that they have decided in favor in, and I have to send those as examples in the writ of certiorari. I do know that. So this is the tip of the iceberg, people. Alright, Rule 11. Certiorari to a United States Court of Appeals before judgment. A petition for a writ of certiorari to review a case pending in the United States Court of Appeals before judgment is entered in that court will be granted only upon a showing that the case is of such imperative public importance as to justify deviation from normal appellate practice and to require immediate determination in the court. See 28 U.S.S.C. 2101E. That doesn't apply here. It's already been decided on. Rule 12. Review on certiorari. How sought parties. 1. Except as provided in paragraph 2 of this rule, the petitioner shall file 40 copies of a petition for a writ of certiorari prepared as required by Rule 33.1 and shall pay the Rule 38A docket fee. 2. A petitioner proceeding in forma pauperis, I think that's where you're too poor to pay it, under Rule 39 shall file an original and 10 copies of a petition for a writ of certiorari prepared as required by Rule 33.2, together with an original and 10 copies of the motion for leave to proceed in forma pauperis. A copy of the motion shall precede and be attached to each copy of the petition. An inmate confined in an institution in proceeding in forma pauperis and not represented by counsel need file only the original petition and motion. So pretty much it's easier for prisoners to do this. 3, they're considered to have extreme circumstances, but the court doesn't consider people who aren't in prison to also have such extreme circumstances. But anyway, that's regardless. 3, whether prepared under Rule 33.1 or 33.2, the petition shall comply in all respects with Rule 14 and shall be submitted with proof of service as required by Rule 29. The case then will be placed on the docket. It is the petitioner's duty to notify all respondents promptly on a form supplied by the clerk. The date of filing, the date of the case was placed on the docket, and the docket number of the case. The notice shall be served as required by Rule 29. 4. Parties interested jointly, severely, or otherwise in a judgment may petition separately for a writ of certiorari, or any two or more may join in a petition. A party not shown on the petition as joined therein at the time of the petition is filed may not later join in that petition. When two or more judgments are sought to be reviewed on a writ of certiorari to the same court and involved identical or closely related questions, a single petition for a writ of certiorari covering all the judgments suffices. A petition for a writ of certiorari may not be joined with any other pleading, except that any motion for leave to proceed in forma pauperis shall be attached. 5. No more than 30 days after a case has been placed on the docket, a respondent seeking to file a conditional cross petition that otherwise would be untimely, shall file with proof of service as required by Rule 29 40 copies of the cross petition prepared as required in Rule 33.1, except that a cross petitioner proceeding in forma pauperis under Rule 39 shall comply with Rule 12.2. The cross petition shall comply in all respects with this rule and Rule 14, except that material already produced in the appendix to the opening petition need not be reproduced again. A cross-petitioning respondent shall pay the Rule 38A docket fee or submit a motion for leave to proceed in forma pauperis. The cover of the cross petition shall indicate clearly that it is a conditional cross petition. The cross petition then will be placed on the docket subject to provisions of Rule 13.4. It is the cross petitioner's duty to notify all cross respondents promptly on a form supplied by the clerk. The date of filing, the date of the cross petition was placed on docket, the docket number of the cross petition. The notice shall be served as required by Rule 29. A cross petition for a writ of certiorari may not be joined with any other pleading except in motion leave in forma pauperis shall be attached. The time to file condition cross petition will not be extended. 6. All parties to the proceedings of the court whose judgment is sought to be reviewed are deemed parties entitled to file documents in this court unless the petitioner notifies the clerk of this court in writing of the petitioner's belief that one or more of the parties below have no interest in the outcome of the petition. A copy of such notice shall be served as required by Rule 29 on all parties to the proceeding below. A party noted as no longer interested may remain a party by notifying the clerk promptly with service on the other parties of an intention to remain a party. All parties other than the petitioner are considered respondents, but any respondent who supports the position of the petitioner shall meet the petitioner's time schedule for filing documents with the following exception. A response of a party aligned with petitioner below who supports granting the petition shall be filed within 30 days after the case if placed on the docket, and that time will not be extended. Counsel for such respondent shall ensure that counsel of record for all parties receive notice of this intention to file a brief in support with 20 days after the case is placed on the docket. A respondent not aligned with petitioner below who supports the granting petition, or a respondent aligned with petitioner below who takes the position that the petition should be denied, CPS, or a respondent is not subject to the notice requirement and may file a response within the time otherwise provided by Rule 15.3. Parties who file no document will not qualify for any relief from this court. Number 7, the clerk of court having possession of the record shall keep it until notified by the clerk of court to certify and transmit it. In any document filed within this court, a party may cite or quote from the record, even if it has not been transmitted to this court. When requested by the clerk of court to certify and transmit the record or any part of it, the clerk of this court having possession of the record shall number the documents to be certified and shall transmit therewith a numbered list specifically identifying each document transmitted. If the record or stipulated portions have been printed for the use of the court below, the printed record plus the proceedings of the court below may be certified as the court records unless one of the parties or the clerk of this court requests otherwise. The record may consist of certified copies, but if the lower court is of the view that original documents of any kind should be seen by this court, that court may provide by order for the transport, safekeeping, and return of such originals. Okay, so that's going to be the end of this video. We're already at 12 minutes, and then in the next video I will read Rule 13 and 14.